Hi, I'm Darcel Lobo and I own Dow Law Firm, and here to talk to you today about what assets are not included in a probate. But before we get to what's not included, let's take a step back and make sure we're on the same page as far as what probate is. So probate is the court process where the court oversees the administration of someone's estate, so after they've passed away, and whether there's a will or no will, the court oversees the administration and the distribution of their assets and payments of debts. So if there's a will, the will gets filed with the probate court, and the probate court appoints the person that's been named as the executor and then oversees the administration according to the will. The will is like a set of instructions of what you want to have happen, but the probate court is what empowers your executor to make those things happen. If there is no will and no estate plan, then there's a state law that determines what happens and what assets go to who. So let's talk about what does not go through probate. Well, if you have a revocable living trust agreement, one of the reasons you created that is to avoid probate. So the assets that are in that trust will not go through probate, and they will be administered according to your trust. But aside from that, the short answer is, well, any asset that has a beneficiary designation will not go through probate. That asset will be distributed according to who you've named as your beneficiary. So, for example, your retirement, life insurance, checking accounts, savings accounts, annuities. If those accounts have beneficiary designations, then upon your passing, that financial institution will distribute those funds to whoever you've named as your beneficiary. So you want to ensure that you have beneficiaries named on those accounts, but you also update them as needed. If there's a marriage, if there's a divorce, if you have children, you want to make sure that your beneficiary designations are continually being updated as you have life events that change things. And so besides having a revocable living trust, which avoids probate, and aside from having beneficiary designations, depending on the size of your estate, your estate may be able to use a small estate affidavit to avoid probate and administer your estate without probate. And so, but there's requirements for that. It has to be under $100,000 in value. There has to be no real estate, and there have to be enough assets to pay debts. And I made a video all about small estate affidavits. I'll make sure I link that below if you want to watch that one. But otherwise, if there's no revocable living trust agreement, if you don't have beneficiaries on all your accounts, if your estate does not qualify for a small estate affidavit, then it's probably going to go to probate to be administered. Now, if you're married and you're here in Washington State, you can have a community property agreement, which says essentially what's yours is mine, what's mine is yours between the two spouses, and then probate would not be needed. The surviving spouse would receive all the assets. But upon passing of that surviving spouse, there's probably going to be a probate in order to administer the assets. Here in Washington State, probate is pretty reasonable, but it does add cost. It does add time to the process. But compared to other states, it's not as burdensome as you may have heard in other states, namely California. That's a big one that I hear that clients usually want to avoid probate in California because of the fees and the time associated with handling a probate in California. But here in Washington, that's not the case, but probate is still a process. And for some clients, they want their estate to remain private. They don't want it to be public record and a court record and have the court's involvement in their affairs. And so they want to use a revocable living trust to make it more private and to have that privacy for their loved ones and for their estate. So there's pros and cons to a trust or to a will or to using a small estate affidavit. And so if you have questions about which option to use, if you think you may need to have a probate for a loved one who's passed away, or if maybe you're not sure if it would qualify for a small estate affidavit, or you just don't know where to go and you're thinking about estate planning or probate for a loved one, we'd be happy to help you. You can give us a call. Our number is 206-408-8158, or you can visit us online at our website of dowlawfirm.com. Thank you and have a great day.